Please be seated. Questions to honourable ministers and members of the cabinet. The elected member for East End to ask the honourable minister of planning, lands, agriculture, housing and infrastructure. Question number 16.
I recognise the Honourable Deputy Premier to move the suspension of Standing Order 23, 7 and 8 to allow question time to continue beyond the hour of 11 a.m.
Thank you, Madam Speaker. Madam Speaker, I move the suspension
23, 7 and 8.
23, 7, 8 in order for questions to be asked after 11 o'clock.
The question is that Standing Order 23, 7 and 8 be hereby suspended to allow the questions to continue beyond the hour of 11 a.m. All those in favour, please say aye.
Aye.
Those against, no. I think the ayes have it. Standing Order 23, 7 is accordingly suspended. I recognise the honourable member from the District of Easton.
Thank you, Madam Speaker. Madam Speaker, question number 16, standing in my name, reads, can the Honourable Minister say whether the government made any additional agreements or commitments with Navasoto or any local entity regarding fuel storage in the District of Easton?
Recognise the Honourable Minister responsible for infrastructure.
Thank you, Madam Speaker. Madam Speaker, the short answer is no. I have not authorized or approved any agreement or made any commitments to any entities, either foreign or local, with regards to fuel storage in the District of East End or anywhere else in these islands.
Recognise the member from Easton for a supplementary.
Thank you, Madam Speaker. Madam Speaker, I wonder if the Minister could tell us if Navasoto is working along with one of the entities that is proposing to bid on this project.
Honourable Minister for Infrastructure.
Madam Speaker, just for purposes of clarity, since we last had the question raised by the Honourable Member for East End regarding the bulk fuel storage and the possibility of it being a reality and placed in the District of East End, I have only had one meeting with any interested parties. That meeting was with Navasoto, who, and I'm not quite sure on my dates, but I'm suspecting somewhere between a month, maybe 6 weeks ago, or 6 weeks to 2 months ago, one of the principals came to meet with me to find out if anything else had transpired since we had spoken last, and of course, my answer was simply no. I do not know if he is working or if his company is working with any other entity, because in that short meeting that we had, he did not say to me that he was working with any other entity towards making this a reality. I can only say that he has expressed an interest to try to pursue to see if there is any answer that can be forthcoming, that it would be in agreement with all parties concerned to move the process forward.
I recognise the member from Easton.
Madam Speaker, in the interest of transparency, I need to do this so that the minister does not think I'm trying to blindside him, nor this country. Madam Speaker, I need to ask the minister, if this government, this minister in particular, has gone into any agreement with one Donald Thompson of the Cayman Islands, who emphatically says that he has the documentation signed by this minister on approvals, the final approvals for planning an agreement to put the pipes in from East End through the North Sound to the airport, and an option of through the East-West Arterial.
Honorable Minister for Infrastructure.
I need to make sure you're not blindsided.
Madam Speaker, I appreciate the member's question, but my only answer can be is I know nothing about anything that the member from East End is speaking about with his last discourse with the supplementary question that he asked me. I have not met with anyone. I certainly would not have gone to the point of even considering any such agreement without public discourse and debate on the matter. I would never do such a thing. But the mere fact that the member asked the question seems to me like somebody is saying that that's the case.
Not somebody.
And I want to state emphatically that I have not met with anyone else outside of the meeting I told the member from East End about with Navasota, asking if there was any progression of the matter, which I informed him. So whoever he speaks about and whoever seems to believe that there is some agreement, I can tell you, Madam Speaker, and this entire country, that no such thing exists, or neither has any such thing been thought of, because there's a new twist now. It's going through the North Sound. Never heard that one before.
Madam,
Member from Eastern, I'll allow 2 more supplementaries.
thank you, Madam Speaker. Madam Speaker, my question to the minister is that I have been promised that the documents will be delivered to me. Will the minister be receptive to, would the minister be receptive to receiving those?
Honorable Minister responsible for planning.
Madam Speaker, the member has asked me a question, and I'm not trying to evade or avoid an answer. But I repeat, no such document exists. If any such documents that are purported to exist are passed on to that member, I would be happy to receive these documents so that I can see where the dream is coming from.
Last supplementary, member from Eastern.
Thank you, Madam Speaker. Madam Speaker, I wonder if the minister can tell us if he's aware that the one Donald Thompson is representing one of the entities who plans to bid on this. That is the project, but that is the local partner contact for one of those entities.
Honorable Minister.
Madam Speaker, the short answer to that is I am certainly not aware of that to be a fact. Now, if the member will go back in time, when similar questions were asked in this House, and I had said at that time that Mr. Thompson and Mr. Chris Pope had met with me, and the gist of what transpired at that meeting was that they were saying that Navasota needed the technical expertise that they had access to make this thing happen. And they were simply paying a visit to me to tell me the role that they needed to play in the process. And I simply said to them, you are telling me what you're telling me, so you go and talk to Navasota, because my only role and the government's only role in this would be to try to see whether the proposal was feasible, to speak to stakeholders. I did mention to him, and in fact, the member from East End and the member from Northside both will remember that we had a few meetings about the matter to try to discuss, to see if the matter was something that was worth taking forward, or whether the pros outweighed the cons or the cons outweighed the pros with regards to that matter. And outside of what I've just outlined to the member, I have not had any contact with anybody else with regarding this matter. So I hope that that puts the member's mind in straight course. And I do appreciate the fact that the member might not be consoled too well by my answers, but that is only because I know nothing more to tell him. Simple.
I just don't want you to get blindsided and you think that I'll cut off.
Next item of business. I recognize a member from Northside.
On a matter of procedure, can I have an explanation of why there are not 3 questions standing in my name on today's order paper? Because, Madam Speaker, as you're aware, I submitted 10 questions in accordance with Standing Order 21-1, and I assume that the clerk complied with Standing Order 21-2, the 10 and the deadline was October the 2nd, and those 10 questions were circulated on business paper number 7, which means, Madam Speaker, in my opinion, that in order to be placed on a business paper for this meeting, those questions had to be approved by you as Speaker, which means that all 10 questions complied with Standing Orders 22-1 and 2, and Standing Order 23-6 limits the numbers of questions per member per day to 3, and in my view, Madam Speaker, clearly establishes an expectation for any member submitting questions to have 3 questions which meets all the conditions of standing order on the order paper for the day. And if the government is not in a position to answer the questions, they have to utilize the provisions of Standing Order 23-5 and get up and say they don't have the answer and ask the House to be deferred.
Member from Northside, you would fully be cognizant that the current way the standing orders is drafted, the Speaker does not approve the business paper or the order paper. There is a standing select committee, style after the fashion of the business committee, which is chaired by the Honourable Premier and the other memberships as they are representative of both sides of the House. They set the business for the order paper, and the business has been set as appears on the order paper. I take note of your submissions, but seeing that the standing order does not allow me as Speaker, I would have to defer to the Deputy Premier, who is also a member of that in light of the fact that the Honourable Premier is not here to respond to your inquiries from a procedural standpoint. I recognize the Honourable Deputy Premier.
Thank you, Madam Speaker. Madam Speaker, the Business Committee met. Unfortunately, the Premier is not here, but the other members are here. We requested that the Deputy Clerk contact the ministries and ask them to send their questions, answers down for the sitting. And we also set it out that as they were available, they would be put on the order paper.
Madam Speaker, I wonder if
Member
you
from
or
Northside.
the Deputy Premier could direct me to the standing order or the TOR of the Business Committee that allows the Business Committee to take that action.
Honourable Deputy Premier, as I'm sure you did not anticipate this, you may wish to have some time to respond. If you're able to respond now, by all means do so.
But, Madam Speaker, in fairness, if they made the decision must have been made on some authority of standing order or the TORs of the Business Committee, which they relied on to make the decision not to place the question on order paper because they didn't have the answers.
Honourable Deputy Premier.
Thank you, Madam Speaker. Madam Speaker, for the questions to be placed in the order paper, they have to be brought from the ministry to the Legislative Assembly.
Show me the standing order that says
The
that.
answers.
Show me the standing order that says that.
Let's keep the comments through the chair.
Madam Chairman, there is no standing
Member
order.
from Eastern, have you completed your response? Okay. Member
Madam
from
Speaker,
Northside.
I am not aware, and I would be delighted to be directed to the standing order that says questions can only be placed on an order paper when answers are available. The reason that I have to give 10 days notice and the clerk has to send them to the member being questioned on the day that she receives them in accordance with Standing Order 2012 is so the government will have 10 days to provide the answer to the question. And in the absence of the relevant authority in standing orders, Madam Speaker, I'm beginning to get concerned because this happens to me as a minority in this parliament. Every meeting, I have questions that have been submitted meeting after meeting that don't get answered because they don't put them on the order paper. I put it to you, Madam Speaker, that the Business Committee has no, I submit to you that the Business Committee has no authority not to put business on the order paper that has been circulated on a business paper.
I recognize Honourable Deputy Premier, and after that I will conclude the exchange in that the procedural point has been made, and if there is not a satisfactory response, the member knows full well that he can bring other avenues to deal with it, and the chair will not get into a discourse further on it after this response from the Deputy Premier.
Thank you, Madam Speaker. Madam Speaker, the standing order was not what I was trying to answer the member. The member, I was trying to explain to him what Business Committee had discussed and what Business Committee was doing as far as allowing the questions to be put on the agenda as quickly as possible, which we believe is the responsibility of the Business Committee. The questions were not delivered to the LA. The answers to the questions were not delivered to the LA to be put on the order paper. What the Business Committee said was that we would ask the Deputy Clerk to contact the ministries and ask them to send down their answers as quickly as possible in order for them to be put on the agenda.
Madam Clerk.
Statements by the honourable members and ministers of the Cabinet.
There are no statements on order paper today.
Personal explanations.
There is no personal explanations.
Obituary and other ceremonial speeches.
There is none.
Rising of matter of privileges.
There are no matters of privileges on order paper today.
Government business, bills, first readings. The Legal Aid Bill 2015.
I recognize sorry, Madam Clerk. The bill has been deemed to have been read the first time and set down for the second reading.
The Public Management and Finance Amendment Bill 2015.
The bill has been deemed to have been read the first time and is also set down for its second reading.
Second readings. The Legal Aid Bill 2015.
Recognize the Honorable Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill entitled A Bill for a Law to Reform the System of Providing Legal Aid Services to Persons of Insufficient Means and for incidental and connected purposes.
The bill has been duly moved. Does the Honorable Attorney General wish to speak thereto?
Yes, Madam Speaker.
Please proceed.
Thank you so much. Thank you, Madam Speaker. Madam Speaker, by way of background, this bill is seeking to reform the system of legal aid in the Cayman Islands and in order to, Madam Speaker, among other things, ensure a more efficient and modern management of our legal aid regime, a regime that has been in place, Madam Speaker, since 1975 and has not been changed. Madam Speaker, in 2004, in response to concerns about the rising cost of legal aid in the Cayman Islands, I had asked the legislative drafting department at the time to review the existing legal aid law with a view to making improvements thereon. Madam Speaker, once the initial look was taken on the bill and the existing framework, it was decided that a probably wider and more in-depth review was necessary. And so in September 2005, the Law Reform Commission took over the exercise and prepared their first discussion paper, which was presented in November 2005 for consultation. Madam Speaker, concerns were raised again in the Legislative Assembly in May 2007 regarding the perceived high cost of legal aid in these islands. There were also concerns about the number of foreign attorneys being briefed for legal aid cases. The Commission, Madam Speaker, conducted a substantive review of the legal aid system between October 2005 and February 2008, and a final report was submitted to Cabinet in July 2008, following that exercise, of course. During the review, a range of issues were considered by the Commission as being critical to the determination of whether the legal aid system was functioning with the desired efficiency, Madam Speaker. The Commission looked at, for example, whether the legal aid system may be reformed simply by improving the investigative and means assessment process relating to the grant of legal aid. They also look at whether the system should be administered by the Judicial Department-based legal aid administrator and support staff, or whether it would be more cost-effective to establish other means by which legal aid could be provided, such as by way of a legal aid clinic or public defender's office, or a mixture of clinic, public defender, and private bar members. The LRC, Madam Speaker, also look at whether the recovery system, where certain persons who are granted legal aid are required to reimburse the legal aid fund, whether that system should be improved. They also, Madam Speaker, took a look at whether legal aid fees are too high and should be capped, and whether pro bono work should be mandatory in order to give the public more access to legal services. The recommendations, Madam Speaker, for reform contained in the report were the culmination of in-depth legal research and deliberations, as well as extensive consultation with the public and stakeholders. The report of the Commission was also informed by the examination of several legal aid models originating from other common law jurisdictions, including the UK, Bermuda, Jersey, Canada, Ontario in particular, New Zealand, and Australia. And based on the responses received from stakeholders and its research on the legal aid system in other jurisdictions, the Commission concluded a number of things, Madam Speaker. They concluded that while the concerns expressed by the legislative and executive arms of government focus understandably on excessive cost and the fact that too many of the services were being provided by foreign counsel, the Commission considered that the main issue lies more in the perception of how the legal aid system was being administered. They are of the view, Madam Speaker, that a more efficient administration of the legal aid, while not necessarily resulting in reduced costs, could serve to more readily demonstrate that legal aid funds are being appropriately spent, and thereby satisfying the objective of accountability inherent in legislators' concern. Madam Speaker, the Commission also considered whether an independent legal aid commission would be the best model to administer legal aid, but it was concluded that this may instead add to the cost of legal aid. So the Commission's suggestion was that the current court-administered model of legal aid should be maintained, but that efficiency be improved by the appointment of a specially designated director of legal aid. Huh? Oh, sorry. Sorry, I'm shouting. Sorry. Madam Speaker, the Commission also concluded that the legal aid rules should be amended to make them more precise, as the rules allow for too wide a discretion in what is taken into account in determining the assignments of legal aid. Can you hear me now? Thank you. That the rules, Madam Speaker, do not define nor provide a method of calculating the disposable capital or disposable income of an applicant for legal aid. And it was therefore felt that these provisions were too imprecise, and it was believed that greater clarity could be established by the provision of additional details on these concepts and how they are to be determined in practice. The Commission, Madam Speaker, recommended that the law and the rules be revised to make it clear that contributions may be required of persons above a certain specified income, and that the government may require a charge on property as a condition of legal aid in certain circumstances, and that such contributions may be recoverable and enforceable in the civil court by the Attorney General. Madam Speaker, very importantly, the Commission believed that the present method of provision of legal aid services by the private bar in general offers good value for money. That this type of legal aid system, which is called a judiciary model, provides a high caliber of service and would be far less expensive than the public defender's scheme. Madam Speaker, the Commission also took the view that a legal aid clinic would not be appropriate to provide defense in criminal cases, but could assist in civil cases, and the cost of civil legal aid could be reduced by the introduction of at least one legal aid clinic, modeled presumably of the lines of those operated by the law schools in the region. Notwithstanding the fact that the Commission was of the view, Madam Speaker, that local legal aid costs are not unduly excessive, the Commission believed that the cost can be better contained by capping the cost of long and complex cases. This could be effected by implementing, for example, where appropriate, a tendering process, and such cases could be managed through individual case contracts based on case plans agreed by the Director of Legal Aid after consultation with the respective attorneys. The alternative, Madam Speaker, would be to impose fixed fees for such cases and to provide that there is a right to request a review in certain circumstances. Madam Speaker, I've gone into the background to demonstrate that this has been a work in progress. Several legal aid bills were drafted between 2009 and 2014 and submitted for consultation. Over the years, several persons responded to these bills, including, Madam Speaker, the Honorable Chief Justice, the Court Administrator, the Cayman Islands Defense Bar Association, the Cayman Islands Law Society, as well as the Human Rights Commission. Accordingly, Madam Speaker, the development of the bill has a lengthy history, as you can see. With your leave, Madam Speaker, I will now attempt to highlight some of the main provisions of the bill that is before the House. Yeah, Human Rights Commission. Sorry. Sorry. Madam Speaker, the principal changes being proposed by this bill are as follows. Changes to the Legal Aid Office to include appointment of the Director of Legal Aid, a legislative provision for duty counsel, increase of the rate of legal aid fees, limit on the fees for legal aid, appropriate limits, fixed contracts in certain circumstances, and where appropriate, Madam Speaker, limit on services of foreign attorneys, and overall, greater efficiency and accountability of the legal aid system, including the more robust means testing system. And so, Madam Speaker, the bill contains detailed provision of the scope of legal aid. In Clause 4, it provides that legal aid may be granted in proceedings before a court in the following cases: criminal proceedings and indictment, criminal summary proceedings, and in certain cases, civil proceedings in the Grand Court or Summer Court, and of course, appeals in criminals and some civil cases. It is provided, Madam Speaker, that legal aid may only be granted in family law proceedings if those proceedings involve questions of custody, access, adoption, or maintenance, or other financial relief relating to the welfare of a child, and that legal aid will not be granted in divorce proceedings or for ancillary matters in such proceedings which do not relate, Madam Speaker, to the welfare of a child. The bill, Madam Speaker, in Clause 4, subsection 4, defines family law proceedings as proceedings brought under any of the following laws: the adoption of children law, the affiliation law, the children law, the maintenance law, the matrimonial causes law, and of course the succession law. Clause 4 also provides that legal aid should not be granted in certain civil proceedings, including proceedings wholly or partly in respect of defamation and proceedings relating to elections matters. Madam Speaker, Clause 5 of the bill provides that legal aid in civil proceedings may only be granted if the director is satisfied, after making inquiries under Clause 16, that the applicant appears to have a reasonable prospect of succeeding on the merits of the case. And of course, Madam Speaker, that he or she doesn't have the means to employ a private attorney. Clause 6, Madam Speaker, provides for the continuation of legal aid, for the continuation of the legal aid office and for the appointment of a director to administer that office. There is currently a legal aid office, Madam Speaker, which comprises of administrative officer who assist the judges with legal aid application. However, Madam Speaker, the bill seeks to improve the administration of this office by the appointment of the director who would be responsible for making decisions on legal aid applications instead of a judge, as is currently the case. The director, it is contemplated, will be an attorney of law of at least 5 years called to the bar, and the decision of the director will be subject to appeal to a judge in chambers. And so, Madam Speaker, in those circumstances, the director will be acting in a sort of a quasi-judicial capacity. Madam Speaker, in order to contain or minimize, if you will, the cost of legal aid, it should be noted that the bill provides in Clause 6 that a person who already holds another public office may be appointed as a director of legal aid, where the chief officer is of the opinion that the person can properly combine the dual roles. The bill also contemplates that the director will provide legal representations and give legal advice in some civil matters and in such circumstances as are approved by the court administrator after consultation with the Honorable Chief Justice. Madam Speaker, it is proposed by the Chief Justice that such civil matters will include, for example, one-off applications such as enforcement of maintenance orders and urgent applications for restraint orders and allegations of domestic violence. Clause 7 provides that the director, after consulting the clerk of the court, shall prepare and maintain a list of attorneys who are in active private practice in these islands, and from which will be drawn the names of attorneys who are able and willing to provide legal aid services. And so the director may prepare a roster of such attorneys for more efficient administration of the law. And the roster, Madam Speaker, it is contemplated will include the names of the duty counsel who are willing and able to interview and advise persons arrested for criminal offenses in circumstances set out in Clause 14 of the bill. And I just want to make it clear, Madam Speaker, that these duty counsels are persons who will be in private practice. They are not government attorneys, not a government-appointed attorney. Madam Speaker, pursuant to representations from the Cayman Islands Defense Bar Association and support from the Honorable Chief Justice, it is proposed to increase the legal aid fees to attorneys from the current $135 per hour to $160 per hour. There has not been an increase, Madam Speaker, in such fees for many years, I think since 2003. And this is while the cost of doing business in these islands have understandably increased, in some instances significantly. It should be noted, however, Madam Speaker, that in the interest of ensuring greater accountability of how legal aid monies are expended, the bill also seeks to limit, in different ways of course, the amount of fees which may be paid for legal aid services. For example, Madam Speaker, Clause 8 of the bill provides that the director shall not, in relation to any one legal aid matter, without the prior written approval of the court administrator and the clerk of the court, authorize any expenditure in excess of $20,000. Similarly, Madam Speaker, Clause 25 provides that, subject to some exceptions, no attorney at law shall be paid for providing more than 10 hours of service in any one day. However, the clerk of the court or a designated taxing officer in taxing any bill of costs under Clause 28 may permit the payment of fees for more than 10 hours in any one day if the attorney provides evidence to their satisfaction that they had provided legal services in respect of the relevant matter for period in excess of the 10 hours, Madam Speaker. Another method of capping the limits is that the bill also provides for the payment, Madam Speaker, of legal aid services in complex legal aid cases by way of fixed contracts. And this would seek to restrict the use of, and also seeks to restrict the use of foreign attorneys at law. And I mentioned that has been a source of disaffection among some members of the public for some time. So Clause 21 provides, Madam Speaker, that a director shall only assign legal aid work to a foreign counsel where the case is of a complex matter or complex nature, and where it is not possible to assign the services of a locally admitted attorney at law. Madam Speaker, in assigning legal aid brief to a foreign counsel, it has to be established that every reasonable effort has been made to obtain the services of a locally listed attorney, and that there was none available or willing, for that matter, to advise or represent that particular client. Clause 24 of the bill provides for the remuneration of assigned attorneys at law in complex legal aid cases, Madam Speaker. A complex legal aid case is defined as a case which satisfies 3 or more of the following criteria. For example, that a successful defense to the charge requires highly specialist knowledge, or that the elements of the offense are of a technical nature, that the elements of the offense involve an international dimension, or that a successful defense against the charges required a combination of legal, accountancy, and investigative skills, or if the charges are based on allegation of terrorism, or, Madam Speaker, for example, the offense involves complex financial transactions or records. Madam Speaker, the director may by tender procure legal aid services in such type of cases. And it is provided in Clause 24 that the fees and costs attached to the proceedings in complex legal aid cases shall be paid in accordance with the terms of the legal aid contract negotiated between the director and the attorneys, as well as the court administrator. And that the director, with the approval of the court administrator, may, Madam Speaker, and receiving written representation from the attorney, allow for an upward adjustment, an uplift, if you will, in the agreed fees if during the conduct of the criminal or civil proceedings there is a material change of circumstances which justify such an uplift, Madam Speaker. Madam Speaker, I think I mentioned earlier on that one of the issues highlighted repeatedly throughout the lengthy review undertaken by the Law Reform Commission was the need for a more transparent and efficient administration of legal aid. To this end, Madam Speaker, the bill provides more detailed provision relating to means testing. That is, Madam Speaker, an investigation into the applicant's finances in order to decide whether or not he or she has the ability to pay for an attorney. And so, Madam Speaker, if you look at Clause 21, for example, Clause 16.2, I think it is. I just make sure. Yes. Clause 16.2 of the bill, Madam Speaker, with the permission, it reads that the director shall, and each application for legal aid certify in writing to the court administrator that action was taken pursuant to this section to evaluate the means of the applicant and shall specify the action taken, and no certificate shall be granted unless such certification has been given. So, Madam Speaker, as an effort being made to tighten up the means inquiry that is required before a certificate can be granted for legal aid. Madam Speaker, the bill also contemplates the reporting, annual reporting to the Legislative Assembly of the operations of the Legal Aid Office. If I might, Madam Speaker, we believe also mention clause 30 of the bill. It provides that upon conclusion of any proceedings, a person who receives legal aid, if a person who receives legal aid succeeded in obtaining for example, a money judgment or an order for the recovery of any land or other property, the Director of Legal Aid may order that person to pay a contribution or an additional contribution towards the cost of that person's representation, and such contribution shall constitute a debt payable to the government. And so where any land is recovered as specified, Madam Speaker, the Director may direct that such land shall be stand charged in favor of the government with the full amount of the contribution the applicant is required to contribute under his certificate. Madam Speaker, I think I've focused so far on the main provisions as I deem them to be in the bill. And the bill itself attempts to be fairly comprehensive, but like most of the legislation, it will require the assistance of a further clarification or amplification, if you will, by way of regulations. And so it is proposed, Madam Speaker, that regulations will be promulgated to deal with many of the other issues covered in the bill in greater details. Clause 42 provides, for example, that the Cabinet must consult with the Chief Justice in the making of such regulations, and that the regulations will provide, for example, the information to be supplied by an applicant to the Director to assist with the means inquiry, that the regulation will cover instances such as the cases in which a person may be refused legal aid, including by reason of his conduct as an applicant. The regulations, Madam Speaker, may cover matters such as the management of standard legal aid cases where the cost exceeded $20,000, and may deal with matters like the recovery of contributions from the assisted person. It may also cover, Madam Speaker, taxation of bills of costs submitted by the attorneys in legal aid cases and for review of the appeals from such taxation. So, Madam Speaker, I think that sort of covers the main provisions in the bill before this House. And as I mentioned at the beginning of the presentation, it is an initiative, Madam Speaker, to improve our legal aid regime. And it has taken quite a while for it to get this far. But I certainly wish to thank those who have taken part in this exercise. In particular, again, I wish to thank the Honorable Chief Justice and his colleagues in the judiciary, the court administrator, the Cayman Islands Law Society, the Criminal Defense Bar Association, the Human Rights Commission, the Office of the DPP, the Law Reform Commission, and of course, Madam Speaker, the Honorable Premier and colleagues in Cabinet, as well as the caucus. And I commend this bill to this Honorable House.
Does any other member wish to speak? Does any other member wish to speak? Final call. I recognize the honorable member from the District of Eastern.
Thank you, Madam Speaker. I certainly could not allow this opportunity to pass. In that, particularly, I want to say that the more things change, the more they remain the same. And I guess I should add also that, oh, what tangle web we weave. I guess I'll add on when we're trying to increase our political fortunes. Madam Speaker, I recall quite vividly that the now Premier and I took to the streets against the now leader of the opposition in 2009, late 2009, on a similar matter. It seems like people have short memories. When it was proposed to take the legal aid and put it under the then leader of government business, I remember certain remarks being made by, or statements being made by the then leader of government business about certain criminals shouldn't be getting legal aid, should just go jail and the likes. And we said, no, you cannot do that, and everybody has a right. Along came the new Constitution, which gave us a Bill of Rights. The Attorney General returns to these hallowed chambers, not as a member, a full member, but as an official member. And we have since spoken quite passionately about the need to protect criminals or those who are on the other side of the law by virtue of ensuring we take care of, we are not seen to be not supporting them and giving them fair representation. And I recall that this now Attorney General in the constitutional talks as well, Madam Speaker, and I can't quote verbatim what he was saying, but I can tell you that he took us to task. It was either at the West End or one of those talks in 2007, 6, somewhere between 2006 and 2009. He and the then little governor, we spoke about the separation of powers and the governance and how we need to ensure that the Constitution reflected that. Pardon me? Papa Smurf? The little rat. Anyway, Madam Speaker, I state all that to say those are my memories and more. The Law Reform Commission has been, Ian Patrick Brown has been after this for a long time. I now come back to 2009, late 2009, after the general election, the first Finance Committee, wherein one of the members then brought a motion to the floor under the Finance Committee. Mr. Seymour, for us, requesting Finance Committee to change the subhead of Finance Committee. Madam Speaker, we fought to prevent the lead of government business from doing that. And Madam Speaker, with your permission, I'm going to quote some of the edited Finance Committee excerpts.
Permission granted. Do you have a copy for the chair?
No, Madam Speaker.
Sarge, could you ensure that I have sight of a copy? Thank you. Please continue.
Thank you. Madam Speaker, after much debate in Finance Committee, and I should add that only the now leader of the now Premier and I were here from the PPM contingent. And the now Premier said, and I'm only going to read the relevant parts, unless, of course, someone would wish that I do otherwise. Mr. Speaker, Madam Speaker, not very long, so I might as well read all it. He said, Mr. Chairman, at the time the now Financial Secretary was Chairman, Mr. Chairman, I wish to express the concerns of the opposition in relation to the way this very important matter is being dealt with. The opposition has had no time or opportunity to consider what is being proposed. We are not privy to the presentation apparently made to the government by Mr. Macfield and Ms. Andor, Mrs. Karen. Mr. Chairman, in almost 9 years in this House and Finance Committee, I've never seen anything quite like this. Here we have the matter of legal aid for a country, a lot of money, but more importantly, a matter that is key to preserving the rule of law and ensuring that our justice system is fair to all who are charged with serious offenses to have access to representation. And that after 8:30 p.m., the opposition has been presented with a fait accompli, because while the motion asks for the government to consider the matter, the speech just made by the leader of government business makes it quite clear that the government has met, considered this matter, taken a decision, and that this presentation in Finance Committee is merely a formality. A matter of this consequence ought to be, in my view, moved on the floor of the House as a substantive motion with adequate notice so that all who have a view about it can have an opportunity to consider it. Where are the views of the Attorney General in relation to this matter? Where are the views of the Chief Justice in relation to this matter? In fact, where is the AG himself? I know he's not a member of Finance Committee, but ordinarily, on a matter such as this, I would have expected that he would have been here so that he could indicate what he thought about the matter. And then we have, Mr. Chairman, the staggering proposition that responsibility for the dispensation of funds for legal aid services is to be given to the Premier designate, the leader of government business, whatever we want to call him at the moment. Just the appearance of the chief elected official in the country having it within his or her remit to decide whether or not certain funds are paid with respect to legal aid, the image that that represents to me, Mr. Chairman, is extremely worrying. Then, Mr. Chairman, beyond that, what opportunity has been given to any other lawyers to make a bid for what is essentially a contract? Because at the time, Madam Speaker, it was about I think the Attorney General term for that is public defender's system. And he goes on about how the Law Reform Commission wrote out a long report about it, and the last paragraph says, we had the Law Reform Commission write a long report. They have done a lot of work on this matter, and yet we seem to just dismiss that. Or the government seems to have dismissed that to sit in their caucus and in privacy and make these decisions to award this contract to two local practitioners, both of whom I have a great deal of regard for. But that's not the point. This is just wrong, the way we are going about all of this, Mr. Chairman, and I beg the committee to reconsider this. Let's at least defer a decision on this until proper opportunity can be had for the matter to be looked into and carefully considered, for us to get to the views of the Attorney General and the Chief Justice at a minimum, and not to mention the views of the lawyers who are going to be affected as a result of this decision. Now, Madam Speaker, I totally agreed with the now Premier at that time. But the most important part of our opposition, and I should add, Madam Speaker, was only two of us who voted against it. That was the now Premier and myself. My good friend from Bardentown wasn't here, from Cayman wasn't here, and the Minister for Works wasn't here as either. Madam Speaker, where I part company with what this government is doing is when they're going to allow a minister to be responsible. It's precisely what we didn't want when the UDP government proposed it. That's precisely what we didn't want. Madam Speaker, and I'll go through the bill in some detail in a little bit. But Madam Speaker, we, this House, within the next week and a half, I hope, will be considering a motion by this government to affect the autonomy of this parliament. In essence, the bigger picture is the separation of powers. And in one fell swoop today, in front of that historical motion that is going to be bring here by the Premier, we're going to have the executive over the judiciary in this country again? So we only thought that the separation was from Parliament, from the executive, and we putting the judiciary under the executive? Madam Speaker, the Attorney General said, don't say that. Well, Madam Speaker, it matters not to me what it says. Madam Speaker, and mine, Madam Speaker, sometimes I tend to be, I can be wrong, but I welcome those who find that I'm wrong to correct me. But this bill, in its definition, says minister means the minister or member of cabinet responsible for legal aid. Okay. Totally agree. There are only 3 other people in cabinet, other than ministers, who has the ability for it to be put under. The Attorney General, Deputy Governor, the Governor herself, him or herself. Madam Speaker, I know I'm not supposed to anticipate, but the motion on autonomy clearly says we're trying to move it from on Parliament, the Legislative Assembly. We are trying to move it from under the executive. Who is this legislature under now, Madam Speaker? It is under the Deputy Governor. So it can only be him that if he is considered one of those others in cabinet that it can go under, we are saying in a few weeks or a few days that we move in the legislative from under him because it's a conflict, because it's no separation of powers. And we putting the legal aid back there? Something wrong with that. Something is wrong with it. Now the Attorney General has... Yeah, we come to that one too. The Attorney General has much more knowledge on this thing called law than I do. And Madam Speaker, as a matter of fact, it's 8 or now there, you know. So I'm outnumbered, but I know what. That side got 8 separate opinions. I only got one. I only have one, but everyone only giving a separate one. I can tell them that. I'm going to be more confused than me. Madam Speaker, what I am saying is that whilst it may not be necessarily going directly on the minister, like we fought against the now leader of the opposition, but it still encroaches on the separation of powers. Madam Speaker, when that motion come up, all I'm doing is reading my papers that I've done all over the place, Commonwealth, about autonomy of Parliament. And then I gotta sit down.
Member from Easton, is this a convenient time for the luncheon break?
Yes, ma'am.
We'll take the luncheon break and reconvene at 2:15 p.m.